So hi everyone. Thank you for joining us. Today we're gonna be talking with Mark, and he's gonna come to us and talk about intellectual property rights in the technology sector. So Mark is a trained lawyer and mediator, actively building a career in tech and innovation, corporate practice, intellectual property, dispute resolution, and impact investment. He enjoys speaking to people in emerging areas of law, impact investment, branding, and personal development and startups. So I am super excited for you to be here and share your work. And without further ado, take it away.
Thank you, Brianna. Okay, I'm very excited to be here too, and it's more exciting because most of you are prepared to hear a law talk, but it's not going to be a law talk. Well, part of it is going to be a tutorial on law anyway, but then it's going to be me talking about how you can make deliberate decisions to make the Black community a much safer and a much better place. It might not seem like it from the topic, but trust me, it's going to be an interesting one. So let's just go right into it. I know a lot of people have a fair understanding of what intellectual property is. A lot of people have heard about copyrights, patents, and a lot of other stuff, and that's really good. But when it comes to tech, it is specialized knowledge. A lot of people don't know what happens there. A lot of people don't know how to apply IP rights in tech. That is what I'm going to be talking about today. I'm going to help you understand what IP rights exist in the technology sector and how to apply them, particularly for Black people, because it has been a problem for a very long time. Black people have not gotten credit for what they've been doing over the years that happened before independence, even after independence, that's continued to happen. So I'm going to be focusing on these areas and areas where you need to focus on as developers in order to ensure that your work is not eroded. In future, you can have your name in places and in products, and they can remain there, and you don't have to worry about it getting stolen. So firstly, what are intellectual property rights? Intellectual property rights are, according to the World Intellectual Property Organization, intellectual property rights are the creator's rights over literary and artistic works, inventions, words, slogans, and symbols. This is a pretty simple definition. It just says you have there are rights that you have over your works you have created, whether they're in literature or in arts. You have rights over your inventions, your words, your slogans, and symbols. There are several types of intellectual property rights, but one thing you must note about intellectual property is that they are jurisdictional. That means the rights that you have once you register your IP in a state or in a country, you cannot enforce them in another country. So they are jurisdictional. Your rights can only be enforced in the country where they are registered. This is a problem, but it's important that you take note of these things because there are situations where people steal intellectual property in one country and implement it in another country. You know this is your idea, you know this is your product, but there's nothing you can do about it. But there is such a thing called a triadic patent or an international patent. Of course, you cannot register IP internationally. It's not possible. That is not a real thing. But you can register in several countries, register your IPs in several countries through one body, which will make it relatively easy for you to go about this. So generally, intellectual property is jurisdictional. It can only be registered in a state and enforced in the state or in the country where it is registered. And just like every other right, it can be enforced. Just like every other, it can be enforced in court. And in some countries, you can even get criminal liability for infringing on the intellectual property rights of another person. It is that serious in some places. So yes, it's a very serious right, though we overlook it, especially in the tech sector, in the tech business. We tend to overlook intellectual property rights because we just want to build, we want to design, we want to grow things, we want to develop things, we want to develop solutions. So we don't want to worry about issues about rights and, property, intellectual property and rights. You don't want to worry about it, you just want to build. But it's important that you take note of these things because you cannot have a community if you don't have your name etched into something. That is the problem with the Black community right now. A lot of innovators, a lot of innovations are going on, a lot of things are being developed by people, but they cannot be tied down to anybody because most of the things either were not registered or they were stolen and duplicated. So it becomes difficult to register. So for this particular talk, I'll be focusing on just 4 types of intellectual property. They're on your screen right now. One is copyright, the second is patent, the third is trademark, and the next is trade secrets. For copyrights, according to the World Intellectual Property Organization again, copyright is the protection of literary and artistic works. These include writings, music, and work of the fine arts. And as such, paintings and sculptures and technology-based works such as computer programs and electronic databases. I want to emphasize on the last part, technology-based works such as computer programs and electronic databases. This means some of the things you do on your computer, some of the programs you develop are protected by copyright. But it is dicey because copyrights, depending on the jurisdiction you are in, some countries protect programs with patents, some countries protect programs with copyright. But the general idea is that your computer programs and electronic databases are protected with copyright. A peculiar but very useful feature of copyright is the fact that once you publish or you document that idea in a form that is tangible, it acquires copyright protection automatically. So you don't need to register the copyright really. Once you have published it in a form that is visible, it becomes copyright protected. So for people who upload videos to YouTube, once you make the video and it becomes, and it's in hard copy form, once you make the video and it's on your phone or you upload to YouTube, it acquires copyright protection. If you write your codes, the moment you push to GitHub, it acquires copyright protection. It's always safer to still register with the copyright registry. But just so you know, for copyrights, once you have published your codes or published your videos or pictures or whatever it is you want to publish, it acquires copyright protection. Another beauty about copyright is that copyright has the longest ownership tenure. Generally, under copyright, your intellectual property remains yours for a much longer period. Unlike other rights, like other intellectual property rights, copyrights can last as long as 70 years. So it is yours for as long as 70 years before other people can use it. But the problem is, even though copyright is pretty common, we hear a lot about copyright, most people don't understand how it works. This is simply because most of us do not read the terms and conditions of sites we publish our works into. If we did, we would know how much of our rights over our creative works we sign away or just give up totally. Most of those things have it in their terms and conditions that once you agree to use the site, you are giving up rights over your intellectual property or you're giving up part rights over your intellectual property. And this is a problem. There are lots of Black content creators on various online sharing platforms. And more often than not, I hear complaints about the theft of their intellectual properties by big corporations. These things are bound to happen, yes. But there are better ways to protect your works. Copyright is such a broad subject, but I'll get back to it in a bit. I'll come back to it to explain better how you can actually harness the power, the gift that is copyright, if I can use that word, to protect yourself and protect the Black community generally. So the next type of intellectual property is patent. According to the World Intellectual Property Organization, a patent is a document which describes an invention and creates a legal situation in which the invention can normally be exploited with the authorization of the owner of the patent. A patent in this sense is more encompassing than a copyright, but this is because patents are more difficult to acquire, they're more difficult to get. And they're more difficult to get because patents are usually more common in areas of innovation that are technical or are demanding of more development. For example, now, you want to use a patent to register an engineering design. That is what it is for. You want to use a patent to register a software in some jurisdiction because these things have become technical. So they have to verify if what you are registering is original and is authentic to you. The next thing on the list is trademark. A trademark is a recognizable sign, design, or expression which is capable of distinguishing the goods or services of one enterprise from those of the other person. Your trademark could be your logo, your trademark could be your tagline, your trademark could be anything that distinguishes your products from that of the other person is your trademark. A lot of you have videos on YouTube with a logo for your video. That logo is your trademark. A lot of you have content on GitHub. Some of you have avatars. That avatar is your trademark. You may not know this. You may not know that you need to protect these things, but they are there. You have to protect them. You might not know. A lot of people don't know, but they require protection. And the reason they require protection is because your identity is at stake, your integrity. Somebody could use your trademark on a product that does not tally with the kind of quality, the quality of service you deliver, and that's going to be a problem for you. You want to protect your trademark so you know and you can recognize that this is you and this is you alone. The last thing on the list are trade secrets. According to the United States Trademark and Patent Office, trade secrets consist of information and can include a formula, pattern, compilation, program, device, method, technique, or process. So basically, trade secret is a very important part of your creation. This is the substance that makes such a creation what it is. The trade secrets are usually common in food and beverage industries, but there are trade secrets in tech industries too. For example, if you found a cure for COVID using a nanotech, there are several intellectual property you will need to protect. And one of them is trade secret, which in this case may be whatever formula you use to make the nanotech work. I'm trying to run through the types of intellectual property because that is not the crux of my conversation tonight. That's not the crux of my session tonight. So now that we have identified the relevant types of intellectual property, how do we determine how they apply to tech? Now we are coming home. How do we determine how they apply to tech? Most technological innovations do not fall under a single intellectual property. That is the peculiarity of the tech business. Most of you are software developers, some of you are content creators, some of you are UX and UI designers. Generally, most of the things you do in the tech business do not fall under one type of intellectual property. For example, I'll use software as an example. When you design a software, your software falls under the 4 types of intellectual property I just outlined now. Firstly, you have to copyright the copy and the images you are using for your software. The images and the copy in this case, the content, the text you'll be incorporating to your software, you need to copyright, you need to protect them using copyrights. This is protected separately because it is a separate entity under the intellectual property law. When it comes to programs, your APIs, your plugins, the main program that runs, the program that you have designed, that's the code itself, you protect it using patents. This is dependent on jurisdiction. Some jurisdictions will protect your software programs using copyright, but some will protect using patent, but it is more common to use patents to protect your copyright. So for standalone programs like apps, APIs, plugins, software programs, you protect them with patents. I was using the example of software to tell you how in tech, most of the things you do not fall under one intellectual property. So I've said the copy and the images, that's the content of your software now, and the images you use, that's the UI design of your software, is going to fall under copyright. But the program itself is going to be protected under patent. Then your logo, your tagline, your slogan is going to be under trademark. The trade secrets now will be used to protect the software architecture, the wireframe, and the documentation of the software. So most times the documentation are put online for everybody to see, to be able to use, but there are some software you build that you know the underlying architecture of the software is not something you want public. That is a trade secret because you know that is what, if that is discovered, the idea behind how your software works is now in the open. So as you can see, as I've outlined, the peculiarity of the tech industry shows that for one program, you would need at least 4 intellectual property protections for them to ensure that they are fully protected. Because if you leave one arm open, if you did not protect it in one arm, you risk losing every other thing. It's risky to leave any part open. This is the reason why you should always speak to a professional, so he or she would be able to tell you how and what parts of your program or your technology or your innovation requires protection. So how do you protect your intellectual property? First, and which is the most important thing, you should speak to a tech lawyer. It is very important. I already mentioned earlier that most times your product or your innovation requires more than one intellectual property protection. So you must speak to a tech lawyer. Sorry, I forgot about this slide. You must speak to a tech lawyer to help you understand the areas your protection should cover, the things on your program, and the specific protection that will be required for those parts of your program. The next thing is you should not wait till your project is complete to begin protection. I've had an issue come up before me where the innovator, the creator in this case, was developing a software. He waited until he had finished before pushing it. But that was a mistake he made because his partner went ahead and used the same program and registered the patent. So the patent was not in his name. That's where the problem came up. So once you have an idea and you can document it, do not wait until you've built before you can register. You find a way to register your patent or your design immediately. Thirdly, do not use another person's IP without their permission. If you use another person's intellectual property without their permission, you risk losing your own. You risk losing everything you have built the intellectual property around. The second to the last thing, document and track your changes. This is very important because the thing about intellectual properties is that they are time bound. Usually, the rights over intellectual property accrues to the person who registered it first or who published it first. So when you document and track your changes, if you are developing something, during your iterations, you are making changes to your software, you're making changes to your UI or your UX on Figma or Adobe XD, whatever you are doing, keep track of your changes. So if an issue arises, the timestamp on those changes you made will be what will show that you were the first in time. It is this timestamp that will show you were the first in time and will, in that case, protect you from any liability or help you enforce your rights. And again, I'm emphasizing this point again, speak to a lawyer. Speak to a lawyer who is specialized in this area. Now, so I'm done with the lecturing part of this session. So I'm going to go to the main substance as it relates to the Black community now. The whole world runs on innovations. Every big corporation is born from innovations. Someone created something that everyone wanted. That is basically what business is about. Somebody creates something everyone wants, and it does not matter if the idea is stolen. The consumers do not bother themselves with that. They just want a product, and if you provide a solution, they buy into it. And that's a problem in itself. But that is not what product designers or developers should bother about. As Black people, we have invested so much ideas, so much innovations into the world, and we get very little credit for it. This is because we spend so much time creating and building, hoping that if we create and build enough, our societies will accept how valuable or how important we are to the whole system. The world already knows we are valuable. The world already knows we are important. The problem is accepting that fact. And you cannot make them accept that fact by building more. You would make them accept that fact by making sure they do not forget your name. How would they not forget your name? When you build your products, make sure you register them, make sure you protect them, make sure they are recognized as your product. And the only way they can be recognized as your product is when you register and protect your IP. The Black community is where it is today all over the world because very, very many people's innovations have been stolen. Those that were not stolen did not register. Those that registered decided to register through a person who they assumed had a better and more welcoming skin tone. That is a problem. I keep emphasizing that it's a problem because recently I was on Twitter and I was reading a tweet about Amina Mikoli, I hope I got her name right, where she was complaining that her image was used by a company to produce dolls. That's intellectual property theft. And in this instance now, if she had registered that copyright or registered her image as a copyright or as a patent, it wouldn't have been a problem to enforce. Once you are building a brand for yourself, remember to always put your name to it. Register it, let your name and your product go together. So no matter where it goes to in the country where it is registered, your IP is safe. Black people must be deliberate about protecting their creation. The best way to do this is to ensure that their intellectual property, the best way to do this is to ensure they protect their IP, that is their intellectual property, as much as they want to create. I know for developers, I was a front-end developer for a while, and I know this for developers, we generally do not want to bother about the legal aspects of things, policies, compliance, and all this. We just want to create and provide solutions, but it's important that you take note of these things. If you do not take note of these things, you will end up becoming a sub to somebody who stole your idea. You'll be in the living room one day and you'll discover that your product is somewhere being used by somebody else. Your name has to be there. Big corporations all over the world now are built, like I mentioned earlier, are built on ideas, are built on innovations. If the Black people, the Black race all over the world want to actually become the kind of people that will be accepted, become the kind of race that people would know, yes, these people are this kind of persons that we can no longer ignore their rights, we can no longer bully them, we can no longer oppress them. It goes beyond just protesting. Yes, protests are good, but we must build corporations that have our names on it. We cannot share rights, we cannot hide. You must come out, register your patent, let them know this thing was built by a Black man. The slave who made the whiskey, Jack Daniels, was not given recognition until 2016. That's 150 years late. It was that particular whiskey. He came up with the formula 150 years before he was recognized for it. Understandable, this was during the slave period, but this erosion of ideas, this erosion of innovations has continued up until this moment. I read it all the time on the internet, especially from content creators. People stealing your ideas, people stealing your posts, people stealing your down to big, and these thefts occur from big corporations mainly. I hear people post things on their website, post videos, and CNN is using it without asking for permission. I hear people create images for themselves, and CNN or a bigger corporation is using it without permissions. These things are littered all over the internet. Yesterday, I was in Harold's session, and I could not help but wonder what he was doing to protect his image, because whether I don't know if he's listening, but whether he likes it or not, he's building a brand for himself. He has to protect that image for himself. So no matter where it is used, no matter who tries to use his image, it can be traced back to him. Even if he decides to give the right of use to everybody can use his right. That's not a problem, but it should be traced back to him. That is the same thing for every Black person. If you are creating anything, even if it is open source, you want everybody to be able to develop, build, and iterate on your design. Ensure you register it as yours first, so it can be recognized as your original invention, that it came from you. It is important that we begin to do this to help build corporations, to help build bodies that can be identified to Black people. A 2010 study found that from 1970 to 2006, Black American inventors received 6 patents per million people, compared to 235 patents per million people for all of US inventors. Another 2016 study found that Black Americans apply for patents at nearly half the rates of whites. That means Black people have less than 50% chance of owning any IP. And even if they do, it means they have less than 50% chance of owning corporations that are big enough to scale all over the world. Intellectual property is a complex subject for everyone, not just because of its nature of jurisdiction, but because it's specialized knowledge, especially in the area of tech. People can mix it up. People can, get it wrong when it comes to how to go about it. That's why most times people give up on trying to understand how intellectual property works, because they just think, how do I break this down to know which parts to protect? How do I go about protecting my IP? There are several ways you can do it, and it is important that you put in as much work into protecting your IP as you're putting into creating that project. Because when you protect your IP, you're not just protecting your own design, you're protecting the entire Black community, you're protecting the legacy of the entire Black community. Because when we all leave this world, when we all leave, it is these things that we have created that will be remembered by. And there is no way we'll be remembered if our names are not there. They should not forget our names. They must not forget our names. We must put our names to every design we build. We must put our names to everything we do. You're a UX designer, you're a UI UX designer, you're a software developer, you are whatever it is you're doing in the tech industry. Make sure you register your IP, because in the long run, you'll be building a profile for every other young person who is coming up. Because when people see Black innovators with their names everywhere, it will inspire the younger generation to want to innovate and put out more development, put out more innovations, and register it in their names too. There's so many there.
Hey, Mark.
Yeah.
Sorry to cut you off, but we have just 2 minutes left. So
Yeah, sure.
I was wondering if we could get. Yeah, I was wondering if we could get one question, or do you want to just wrap up and maybe we can get one question? Sorry about that.
Yeah, I'm going to wrap up. I'm done already. So I just wrap up and get one question.
Yeah. Okay, great. So we've got a lot of questions around, what would a lot of our developers start off with GitHub, and open source projects. So what would be your advice to them about protecting their work, their open source work that they might have on GitHub or any other open source technology?
Okay, great. Once you post your codes on GitHub are protected by copyrights already. Once you post them to GitHub, they're already protected. But because the conditions of GitHub, you can make them open source, or make your repositories private, or you can make them open. If you make them open, it is assumed that you want everybody to be able to download your codes and use them. If you make them private, it means you're keeping them personally for yourself. But once they are there, once they are on GitHub, I believe you're protected by copyrights. But if you see that you're developing something that's going to be very big, you alone know this, I would advise that you make your repositories private at some point, then register your patents or whatever it is you need to register. Speak to a lawyer, determine the things you need to register, then register them. Putting your codes on GitHub is not a problem. You can put them on GitHub, but ensure you protect them. And if you're not protecting them, if you want them to be open source, just ensure you make them private or you make them public. But they are protected either way. That's the thing about copyrights. Once they are published, you have copyright protection automatically.
Okay, great. Thank you so much for sharing this. Yeah. And I guess we're done. Bye.
Thank you very much.
Yeah, this was super interesting for me. So I will definitely be following you on Twitter.
Yeah.
All right. All right, let's get to another call, but thank you for your time.